So we'll go ahead and get started. Welcome, everybody. It's great to see you all again. Thank you for coming to Coco TAN, TAN, Tuesday Afternoon Networking live stream seminar. We're also streaming live on Facebook, YouTube, 一直播, Weibo, and TikTok. We'll be recording this Zoom meeting to upload to YouTube, but we're so glad you're joining us live today. You've probably heard of the classic book, Think and Grow Rich by Napoleon Hill, because they say it contains money-making secrets to change your life. But once you're rich, then what's next? The answer is staying rich, of course. Hi, my name is Coco Tan. I'm a realtor with Keller Williams Realty in the San Francisco Bay Area. If you wish to receive the latest videos and seminar updates, please feel free to subscribe to my YouTube channel. I have a big QR code here on my wall. And also here is my WeChat code. You can add me as your WeChat friend and join my live stream WeChat group. We're in the first session of our Think and Stay Rich series. Today's topic is unique because we have 3 experts. Instead of talking about how to conquer the housing market, it is about title, estate planning, and living trusts. We'll talk about how to transfer your assets to your loved ones while minimizing cost, stress, and problems. This is for everybody, even though it is not a light topic. If you do not have a will or have not thought about this topic, this seminar is even more important for you. Because failing to plan is planning to fail. Regardless if you're rich or not, you have an estate. It is your car, home, checking and saving accounts, investments, life insurance, furniture, and personal possessions. What will happen to your estate when you die? You want to control how those things are given to the people or organizations you care most about. To ensure your wishes are carried out, you need to provide instructions stating whom you want to receive something of yours, what you want them to receive, and when they are to receive it. And you want this to happen while paying the minimum of taxes, legal fees, and court costs. It's not pleasant to think about, but look on the bright side. You will get peace of mind from having a solid plan for what happens after you die. Estate planning is not just for retired people or rich people. You cannot predict what may happen in the future, and protecting your asset is important for everyone. To do that, you can draft a will or you can have a living trust. This is what our guests will be talking about today. Our 3 experts today are Linan Yao, Zhai, and Richard Chen. Ms. Linan Yao is our expert on estate planning and living trusts. She's a lawyer from YC Law Group in California. She has helped many clients plan their immigration status and family assets. Ms. Yao mainly deals with estate planning, immigration cases, and other cases involving personal affairs. Mr. Zhai is our expert on taxes. He's a CPA, CFP, MBA, and partner. For over 25 years, he has helped grow startups. Mr. Zhai specializes in tax planning and preparation for individuals, trusts, and corporations, as well as small business accounting, payroll, and benefits. He also does financial planning and wealth management for high net worth clients and business owners. Mr. Richard Chen is our expert on title and escrow, over 15 years in the industry. Having a multifaceted industry background, Richard is known for his knowledge of title and escrow and analytic foresight. Richard has been regularly invited to speak on how to navigate the unique aspects of title and escrow to buyers and sellers. Thank you so much for joining us today, Linan, Bing, and Richard. You're all there?
Yes.
Thank you. Richard, can you start us off with the basic information about ways of holding title? So if you buy a home with someone else, how should you own the property and why does it matter for estate planning?
Absolutely. All right, can you see my slides?
Yes.
Yes. Um,
All right, hi everybody. My name is Richard Chen. I'm with Chicago Title, and just like Coco said, I've been in the industry about 15 years. And throughout my career, it's very often that people ask me that what should we do when we want to buy a house, and what kind of vesting should we be holding. Now, as a title company, I can't really tell you that what vesting you should be holding, because that's something that you should make decision and consult um, um, uh, experts on that. But what I can do today is to share with everybody the common ways of holding title and tell you the difference of those, so maybe it'll be easier for you to make choices. Now, instead of California, and of course you can hold title in as one person individual, or you can do multiple people. Now, as an individual, you can hold title as something like Richard Chen, a single man, or Richard Chen, a married man, or also I can also do Richard Chen, a married person. But if I want to do a sole and separate property, like my own property when I'm in marriage, you got to remember that California is a community property state. So for me to do that, to achieve something like Richard Chen, a married person, as his sole and separate property, I'm going to have to need my wife to consent. Which is she's going to have to sign a deed to deed the property to me. Now, usually if people want to do that, they'll be doing through the escrow, so you can do that ahead of time. Now, other than that, if you're not holding that in one person, the most common way you must have heard would be joint tenants, tenants in common, or community property, and community property with right of survivorship. Now, I just mentioned that community property will be California's community property state. When you talk about community property, that means husband and wife. So I'm going to cover those two later. I'm going to talk about the joint tenants and tenants in common in the most difference of them, because that's what most people are asking. What's the difference between joint tenancy and tenants in common? Now, if you want to have more than one person holding title, joint tenants and tenants in common can both achieve that, and you can have as many people as you want. But usually, let's talk about 2 people or 3 people. Joint tenancy is the one that you can actually decide the percentage that each person is. I'm sorry, joint tenancy you cannot decide. You have to buy them as a whole. Then tenants income is the one that you can decide which person has how much percentage. And for example, if you want to hold 30%, and then your parents want to hold 70%, and each of them will probably hold 35%, that can be achieved by Richard Chen holding 30%, mom holding 35%, dad holding 35% as a whole. And then each person can actually give their share to the person they desire. They can will that portion too. Versus joint tenants, you can't really do that. Everybody has to hold the property together. So in most residential transactions, you will probably see more joint tenants than tenants in common, because people usually sell a residential house, a single family together. Like really, you see people sell, okay, I'm going to sell this residence, but I'm only going to sell my portion. Right. So usually if you want to buy a house that you live there, usually it's going to be joint tenancy. You will see more in the commercial properties where you have the share in the joint tenants way, but that doesn't have to be necessary. All right, so joint tenants, just remember that you own the house as a whole. You have to sell it as a whole. You can't really define the share of each person who own the property. Tenants in common, you can do that. As a result, there's another feature of joint tenancy is if somebody owns the house and pass away, the surviving owner is going to just take over the property. All right, it doesn't have to go through a process called probate. So there's no probate in joint tenancy. Versus tenants in common, each person can will their share to whoever they want. So for tenants in common, it's going to a process called probate. And probate is something that you should really consider and talk to your tax attorney or your attorney about what that's going to be like to have a probate. Also, there are also tax differences in this. Now, before I go that, let's talk about community property. Okay. remember joint tenants and tenants in common are the ones that you can have 2, 3, 4 people. When it comes to community property and community property with rather survivorship, you can only have 2 because it's between husband and wife. Now, the difference of that is community property is when it comes to somebody pass away. All right. Community property with rather survivorship is kind of like joint tenants. The surviving spouse will take over the entire ownership, where community property, half of them will go to the surviving spouse and half of them the spouse that passed away can actually will to somebody. So as you can imagine, whenever you have a will comes in, it might go through a probate. So community property is something that you have joint tenants benefit. Also, it's between husband and wife. So that's something that you should always talk to a tax attorney, because that also involves benefit such as step-up basis. So Coco, that would be the the most common ways of holding title when you talk about more than one person holding title.
So I see the terms of step up in basis. Mr. Bin Zhai, you're our tax expert. Maybe you can tell us what this means for us in the different types of vestings of the holding titles with a single step up basis versus double step up in basis. Bin? And then Richard, you have a chart to compare the 4 vestings in terms of which ones has single step up, which one has a double step up in basis, and then our tax expert can actually address on that term for us.
So I just follow what Richard said about the property holding. And when you have a basis, a step up means you have a gain in the property, So in the Richard's case, somebody died. You have to start to decide who gonna inherit the assets. If you will somebody, then the court gonna decide it, according to your will. But let's stay in the tax side. So let's say you have $1 million house become $2 million. If a owner owns the house, each person depends on your joint tenant, community property. Then we have to decide it. Let's say there's a 2 owner, A and B. A and B owns it. Each person gained about $500,000 from $1 million to $2 million. If one of the spouse died, so that spouse gain will be step up from about $500,000 to $1 million. That's called a single step up. Okay, but the surviving spouse, he's still surviving the first spouse death. So in the tenant in common, because everybody owns by the percentage, you only need to decide the people who died how much step up. So that would be in the chart over here. It's required the probate, but that gain will be step up from the basis to the fair market value. Okay. And in the joint tenant, there's also single step up, although everybody owns the whole property, but only one people need to decide how much step up. But in the community property, California is community property. It basically says the real estate is undivided assets. If one people died, the whole property gonna step up from 1 million to 2 million in my example case. So why it's so important in the single step and the double step up? Because when people die, your capital gain tax is pretty much combined with your estate tax, and everybody so far have a $11.4 million exemption. So as long as your gain is not over that exemption, all the step up are tax exempt. So in the single step up, like in the tenant in common and the joint tenant, only the people who died that they have a step up. But if you have a community property, if two spouses over there, if they die and the whole house step up, so basically your house become $2 million, even the surviving spouse is still living there, you know. So the gain on that house is pretty much tax exempt for 99.5% of people, because only 0.5 people are gonna have a $11 million and over, you know, because that's a really high exemption now. Just so one side notes, Biden is talking about he gonna take out the step up basis, but my humble opinion, he would dare to try that because it's gonna be suicide for a lot of American, you know.
That'd be scary if the step-up base is gone.
Yeah, step up are gonna gone, then they're gonna affect now the 0.5 people. It's gonna affect a lot of people over there, even in the 11.5 million. You know.
That's horrible. Yeah. So so besides this, so that's the step up base is really important. You know, that's we see how the different vesting have the advantages of the step up or the avoiding probate. So just regarding the probate, to reiterate, with joint tenancy and community property with right of survivorship, the person who is still living will automatically inherit the property without probate. However, if all parties pass away, then you have to go through probate. So, of course, the other two, tenancy in common or community property, they automatically require probate. So, Linan, as our estate attorney, can you tell us what is probate and why you should avoid it?
Yeah, sure. Thank you, Coco, for inviting me today. So probate is basically a legal process to administrate someone's estate after his or her death. And it is conducted by the probate court. So court is involved. And if there is a will, then the court will examine if its format is conformed with the law. And then the court will inventory this decedent's assets and liabilities to make sure that all the liabilities are paid off, and then distribute whatever is remaining to the beneficiaries specified in the will. And if there is no will, the person didn't draft a will and just simply died. It's still pretty much the same process, except in the end, the court will distribute whatever is left according to the law. So why we don't like probate and why we are trying to avoid it? For several reasons. First, since it's involved, the probate court is involved, and the court is a branch of the government. So basically, you got a branch of the government involved in your personal matters, right? And we can imagine that whenever a branch of government is involved in our lives, usually, first of all, it's expensive. So why probate and why we are trying to avoid it? For several reasons. First, oh, sorry, is someone playing replay the recording? Okay, I'm going to continue. So the fees that are allowed to be charged by the representative, the court appointed, or the estate attorneys are according to a schedule of fees, and it's based on the total value of the decedent's assets. So remember, it's not based on the net value; it's the total value. And it's like this. So for the first 100,000, they can charge up to 4%, and for the next 100,000, it will be 3%. And for the next 800,000, they can charge up to 2%. And then for the next 9 million, that's 1%. And then for the next 15 million, it will be 0.5%. So basically, I made a chart according to this schedule. And since, I think most of us live in Northern California, and you can, think of, how much your house currently is valued at. And you can see that potentially it can cost you thousands of dollars. So this is the first reason it's expensive. And the second reason is that it's a lengthy process. So we have here a chart that includes all the steps a probate proceeding has to go through before it can complete. And it can happen anytime after a person dies up until like 2 years. But in reality, it will take longer because California court system is usually overwhelmed with a lot of cases. And there's a third reason. Since probate is a court proceeding, and court proceedings usually are public, so there is really no privacy in it. For example, I just went on to the San Francisco probate court and click on a ongoing estate matter. And under that, you can see all the documents filed into this matter. And of course, I redacted some of the personal information, but if you want to see it, you can actually go onto their website and see this case. So this document is called Inventory and Appraisal, and it actually has 42 pages, and in which it lists everything this person owned at the time of his death. And we do not want that, right? We do not want our personal belongings, our assets to be publicized once we die and for everyone to see. And you can also see here at the right side that the date of death of the decedent or the appointment of the guardian or conservator is actually back in 2017, January 16th. So this also proves my second point. It's a very lengthy process. It's almost 3 years, and this case is still ongoing. So for the reasons above, we try to avoid probate as much as possible.
Wow.
I got muted. Thank you, Linan. Sure. I see why you would want to avoid probate. So what are the more direct ways of passing on your assets? You want to share with us that?
Yeah. So now we are talking about estate planning. And before I go on, I have to, first talk about disclaimer first. So basically the information provided in this presentation will just be, a general information, and it should not, constitute any legal advice. But of course, if you have some specific questions that you want to ask, you should consult with your tax professionals or your attorneys. And you can also schedule a virtual meeting with me by scanning the QR code at the upper left corner. Okay, so let's see. So when we are talking about estate planning, what are we really talking about? So I think we can look at it with two phases. So the first phase will be, after we pass away, after we die, we would want our assets, everything we work so hard for our entire life, to pass to the beneficiaries that we nominate, right? We appoint, as quickly as possible and as cost efficient as possible. And if we have minor children, we will want someone that we trust, and the children preferable will continue to raise them until they are adults. And the second phase will be, before we die. Say, it's not the ultimate, tragedy that happens, but for some reason, maybe we're involved in an accident, maybe we got quarantined because of COVID-19, right? And we want someone that we trust can access our accounts, can, pay for bills for us. So basically they can manage our finance or some personal matters temporarily. And we also want, our medical wishes to be honored, to be followed, right? And also, if we have minor children, we will want, someone can take care of them for a temporary basis and without, any interference with the state. Like, say, they wouldn't be sent to foster care families ever. So let's first see some, common ways that we can pass on our assets. So I think the most common way is that making a will. Most people know that, right? So there are certain legal requirements for making a will in California. For example, the person needs to be at least 18 years old, and he or she needs to have the capacity to make a will. And the will must be in writing and must be signed by the person who's making it. And it also needs to be witnessed by two witnesses to make sure that person is with his or her sound mind and is doing that voluntarily. But the problem with will is that it cannot avoid probate. Like I just mentioned before, if the person only has a will, it's still likely that his or her estate is going to undergo the whole probate process. Unless the assets are less than $166,000, it's actually $166,250. That amount is going to be adjusted according to inflation every year. And unless the assets are valued less than that amount, then it's considered a smaller estate. So there will be a simpler process to undergo instead of probate. But if your assets are more than that, then it's very likely that the estate is going to undergo the probate process. So the problem with will is that it cannot avoid probate. The second very common type of ownership is co-ownership. And we see that a lot, especially within the first generation of immigration, because we have to admit this is the most cost-efficient way. There's nothing more extra for them to do. Basically, parents just own the properties together with their kids. So all of their names are on the properties. But there are certain risks to hold properties in this method, and we usually advise against it. And we can see an example here. So let's say there are 3 generations here. So we have parents, they have child A and B, and then child A has 2 kids. That's the the third generation, the grandchild C and D, right? So say for some reason, parents already made some arrangements with child B, and now they have some other properties that they want to pass on to child A, and eventually, giving to their grandchildren C and D. Now parents, want to be cost efficient. They are holding these properties together with child A. So the first kind of risk we are talking about are the risks of potential creditors, because now you have more people than before who are owning the properties, right? So before, when parents only own these properties, child A's creditors cannot go after these properties because they don't belong to child A. They don't belong to child A yet. But now, child A's name is on these properties too. And say, if he or she is in an accident, or maybe he or she is undergo divorce, or maybe he or she simply made some bad choices, then child A is actually exposing these assets to his or her own creditors. And this can, bring very bad results to these properties, especially when parents are actually still owning these properties. So this is first kind of risk. And the second kind of risk is that, so originally when parents and the child A are owning these properties together, what they are planning or what they are assuming is that parents are going to die first, right? And then the properties will just become child A's automatically. And then when child A dies, then these properties will go to grandchild C and D. But let's think about it. Can we be so certain that parents are going to die first? What if child A pre-diseases parents, right? Especially, we are in the middle of a pandemic. Even though they say that older people usually are at a larger risk, but still it's hard to say who's going to die first. So what if child A dies first, and say parents, die shortly after him or her, and they don't have enough time to do some extra planning for this part of the properties. So the properties will go back to parents, right? And then they die. So what happens now? Will grandchild C and D still get all of them? No. Child B can at least get half of them because they belong to parents, right? Not just the child A. So this is actually contradicting to the intent that parents and the child A have when they co-own these properties. So for these 2 main reasons, we usually advise against this type of ownership.
So Linan, instead of co-owning a property with the children, some parents actually let their children have the title. I guess maybe Richard, from a title perspective, what's your opinion for children under the age of 18 owning the title?
Well, once again, as a title company, I can't really tell you whether you should or should not have the child on title, but I can tell you the challenge that we often facing when we see a minor. So when the child is under 18 years old, the child cannot execute documents. So it has to be the guardian to sign. The contract has to be the guardian. Now, just because you're the parents doesn't mean that automatically you become the guardian. You have to establish a guardianship. So if you fail to establish a guardianship, like we see a lot of foreign parents, they want to have their minor children on that because that's a culture in different country. So when they do that and they fail to establish the guardianship, it will result that they cannot sell the property. So let's say if the child is 2 years old, it might be a situation, the extreme situation will be the house cannot be sold until the child turn major, which is 18 years old. So you have 16 years, the property is sitting right there, you cannot sell the property. So that will be the challenge that we often see when we have minor on title.
Got it. So it's not a good idea for children under 18 to hold title. I've also heard of transfer on death deed. Can you help elaborate on that as well?
Yeah, that's actually the third commonly used method, and so the transfer on death deed is basically a deed, and on which the house owner is going to say, if something happened to me, then I want certain people to have this property, and then that deed gets to recorded to the county where the house is situated. But to keep in mind, so first of all, this kind of document to pass on property is going to expire at the end of this year, but all the existing ones will still be in effect. It's not that they are going to lose their effect like after January 1st. It's just after January 1st, you can no longer use this sort of document to pass on properties, but all the existing ones will remain in effect. And something mirrored like transfer on death deed will be the pay on death beneficiary that you can set it up with financial institutions. So basically, you are telling your banks, if something happened to the account holder, I want this person to have whatever left in this account, and these can all avoid probate. But there are certain concerns that we might have. Say, if the beneficiaries are still minors, then this probably will not be the best idea to pass on properties, because it's hard to tell how old they are going to be when they actually get these properties.
I see. And Richard, from title perspective, do you have any comments on death, transfer on death deed?
Now, as a title company, there's no way for us to say something about the legal power of the deed. Deed is fine. Yeah, it should do whatever it's supposed to do. However, this is so rare. We don't really see a whole lot of this deed. So we don't really know that if there's going to be a lot of legal challenge in the future. By me saying that is, we haven't seen enough cases to tell you that this deed does what it's supposed to do, although it should. You got to remember that we're a title insurance company. So when this deed supposed to transfer the title to somebody, but then maybe one case somewhere, all right, and there's a lawsuit get involved because this is so rare, so new. And as a result that we see another title company may have lost money because of the claim, then what's going to happen is, even though the deed is perfectly fine, we as a title company are the ones to insure the transaction. If we know that there's going to be a great risk insuring this kind of a deed, we will stop doing that. And then if you don't have a title company are willing to insure the transaction, then you can't really sell the property, because as a buyer, how would you want to buy a house if no title company is willing to take that risk?
Okay, but you only have 1 month left to use that anyway, so I guess it's not too much a concern at this point, right? Yeah. So if you really want your children to inherit your assets, what would be the most effective way to do so, Linan?
Yeah, so we would recommend a living trust, because it avoids probate and it does not have all the risks that we talk about regarding the co-ownership or transfer on death or pay on death beneficiary. And let's see, so living trust is basically a set of documents, and you can think it as of a private contract, and it's between the property owner, the grantor, and with the successor trustee that he or she names in the trust documents. So it's a set of legal documents, and it can avoid probate. So basically, you are taking things away from the government. You are taking things into your own hands, and the grantor, basically the property holder keeps control, keeps the management, keeps enjoyment of the properties that they transfer into the trust. And it's also very flexible. So as long as the grantor is still alive, he or she can change or revoke anytime that he or she sees fit. So this is just a simple illustration. So the grantor and also acting as the initial trustee will establish a living trust, right? A set of legal documents. And and that's for the benefits of the ultimate beneficiaries. And once the trust is established, the grantor will transfer everything that he or she currently owns under his or her individual name into the trust. And then when grantor passes away, the successor trustee, that is someone that's grantor named in the trust document, he or she will step in and will take over the properties and continue to manage and control them, but for the benefits of the ultimate beneficiary, not for the successor trustee, him or herself, but for the beneficiary. And once the terms of the trust are met and ultimately distribution is distributed, then at that point the trust can end. So once the legal document is established, the grantor needs to fund the trust. That means he or she needs to transfer all the assets that he or she currently owns to the living trust. So you can think of the living trust as like a plate. So once it's there, you have to put things in it. You cannot leave it empty. Otherwise, it will serve no purposes. So I listed some of the common properties that people own, and I will talk about how to fund the trust. So for real estates and the financial accounts, the ways to fund the trust is to change the name of the owner of this account and the house's owner. So for example, if we have a couple, John Smith and Jane Smith, and they established a living trust, probably called the Mr. and Mrs. Smith Living Trust. And then originally, they own all the houses and their financial accounts under their John Smith and Jane Smith, right? And once we transfer these properties into trust using legal documents and sometimes fill out some forms with the financial institutions, then their account's name or their house's name will be under John Smith and Jane Smith, co-trustees of the Mr. and Mrs. Smith Living Trust. And so for personal properties, there will be our pets, our furniture, our jewelry, our basically personal belongings, and our cars. We will use certain documents to transfer them. And that's the same for the business interests. Also, we will use legal documents to transfer them into the trust. And for life insurance and retirement accounts, these type of accounts are probate avoidance themselves. So you can or cannot transfer them into your living trust. That's totally up to the account holder. And if you choose to do so, then they will change the beneficiary's name to the living trust. So in my example, that will be the beneficiary of the life insurance and the retirement accounts will be Mr. and Mrs. Smith Living Trust. And so funding is a very important step, and it's also an ongoing process. But in case the account holder, the assets holder, the grantor of the trust, they all mean the same thing. So in case they forget, we will use what is called a pour-over will. It's basically a simpler version of will to transfer them into the trust. So that will basically say, the intent of the grantor is to put everything into his or her living trust. But since he or she forgets, we are now using this will to transfer them.
So I noticed the asterisk next to life insurance and retirement accounts. What does it mean?
Yeah, because these accounts are already probate avoidance, and there are some tax issues involved regarding whether or not to transfer these accounts. So maybe Bing can talk to us about that.
Okay, if I can insert one advice over here is normally when we do the financial planning or tax planning, we don't recommend to put your beneficiary for the life insurance and the retirement account for the trust to name the trust as a beneficiary. The main reason is it will accelerate the paying tax if you use a non-natural person as the beneficiary for the retirement account. And you will stop the stretch in the old days, as soon as last year, before the Secure Act was passed, the RA, they can stretch. So it's a really bad idea if you pay the tax. If you name the trust as a beneficiary, you probably need to pay the tax within 5 years, according to our act, as over there, And but right now with the Secure Act and the Congress short the beneficiary to pay the tax as long as only for 10 years, but that 10 years is still much longer than the 5 years. So we still hold our recommendation is to make sure your retirement beneficial designation is mimicked for the trust beneficiary, but you don't actually name the trust as the beneficiary. Okay. So that's what Linan says. Maybe you should talk to your consultant. But in the very rare case, if you have a special need kids kind of stuff, you probably do want to set up the trust to be the beneficiary, and you should talk to an attorney about how to design the special trust to pay for your special needs. It's really dependent on the situation.
Thank you, Bin. Yeah. So okay. So Lina, you can go ahead. Sorry for the interruption for the asterisk.
Yes. Yeah. So we just talk about ways to pass our assets after we die. So what if there are minor children involved, right? So the way that trust usually sets up is that for the say if the unthinkable happens when the children are still minor, then the trustee will be able to pay for their health, education, maintenance, and support. So basically, the trustee can draw money from the estate and then to pay for these expenses. So you don't have to worry about that. And we can also set up like delayed distribution in the trust document. So because oftentimes people worry about children getting money too young because there are certain risks involved when simply because people are too young. Maybe they marry too early, or maybe they have some sort of addiction, or maybe they just have impulsive spending or bad investment decisions, etc. So basically, you can set to delay the distribution for a number of years or until the children hit a certain age. So at this point, I usually get asked a lot of questions regarding, if I said, they can only get my money until they're 30 or 35 or even 40. So what if they need money before then, for their school or their, health? So this is up to the trustee. The trustee has the absolute discretion to do that. And in fact, they have the fiduciary duty to make sure that your beneficiaries' well-being are being maintained. And also we will include, the nomination of guardian that we talked earlier, that you can appoint someone that you trust and preferable the children know and like to raise them. So that's protection or pass on assets or someone to take off our kids if we pass away. But oftentimes, we also need the protection when we are still alive. We usually need to have a general power of attorney. So that's in case of an emergency, if we cannot access our financial accounts, we cannot pay our bills on time, then someone can take care of that for us on a temporary basis. And say if we have some preferred ways to be treated medically, then we will have advanced healthcare directive. So in which you can tell others whether you'd like to maybe prolong life or not, or be treated for a certain ways. Especially if there's an emergency and you cannot really tell others how you think and what you want, and if your family members cannot reach an agreement, then this document can really help. And you can also nominate an agent in this document to make sure that they will act on your behalf in case of emergency. And we will also have a HIPAA waiver. That's basically your saying who can receive mental and health information on your behalf. And the last, if we have minor children, again, we will want someone to drop them off school or picks them up. And if they need medical attention, then they can authorize treatment. And this is different than the nomination of guardian, because nomination guardian is like a permanent thing. They are going to take care of the kids until they are 18. But what we are talking about here, the minor seamless protection, we are talking about someone to take care of your kids on a temporary basis. And or if the guardian that you nominated, they don't live in the same area with you, they need time to come and collect the children, then you need this set of documents to make sure that the government, the social service won't take the kids away from you or away from the familiar environment that they live in. Of course, depending on the situation of the individual, the family situation, and also their assets, we have some other protection methods. For example, if you have a business, if you run a business, you should really separate your business assets with your personal assets. So you should establish business entities like LLC or C Corp or S Corp to conduct that business. And some families will use the family limited partnership. That's basically a partnership among a family, and the parents will pass on their interests in certain assets gradually without losing the control of these assets. And of course, for high net worth individuals or families, then there will be irrevocable trust. So basically, they are giving away their assets into the irrevocable trust. But all these methods will have an annual maintenance fees and will have extra costs. So to wrap up, for assets, we will have living trust, proof of will, and the power of attorney. And for health, we should have advanced healthcare directive, HIPAA waiver, and children. If we have children, then we should have minor seamless protection and the nomination of guardian. And we think this is actually a very basic needs for all the individual and the families. And even if you only have like limited assets, or maybe you don't have children, at least you should have power of attorney, advanced healthcare directive, and HIPAA waiver. We need to plan for the unpredicted.
This is very valuable information. Thank you so much, Linan, Bing, and Richard. So we actually have been streaming live on Facebook, YouTube, and other platforms today, and we have compiled some questions that our viewers have for our guests. Before we get into the question and answer session, I would like to give you a quick preview of our next session in the Think and Stay Rich series, which is tax planning. Joining us will be our CPA, Mr. Bing Zhai, to advise us on short-term tax planning strategies we can use before 2020 is over. So, Mr. Bing Zhai, please give us a sneak peek of what we can expect to hear from you in our next session.
Okay, in the next session around the December 8th, around on Tuesday, we can have a tax seminar. We normally host 2 seminars during the year, beginning and before the end of the year. And I think it's more important is before the end of year tax seminar is more important is before the tax season start, because we can still control our rate. If you think some tax rate can be controlled to avoid the tax slot, you're gonna face in the tax season, because at that time pretty much everything is too late. So during the tax seminar, we're gonna talk about for the individual how to save tax, and for the business owner, and we will concentrate our energy probably on the business owner, because they do have the slew of tools RRS can allow them. For the individuals, we also gonna touch a little bit of base about, did you do the normal minimum, how to save tax? Do you have any ways still to pull some strings, or even stunts, to save the tax over there? We're also gonna talk about a little bit to this year's particular for the CARE Act. If you didn't get the stimulus check, how should you get the way when you file the tax to claim the stimulus checks, and the some other stuff. And we also host the Q&A at that time. Maybe you can bring your question. We probably can answer the question for you guys.
Thank you, Bing. So everyone, be sure to join us in 2 weeks on December 8th. So now it's time for the Q&A. If you have a question for our guests, you can type in our chat, or you can use raise your hand feature in the Zoom. We have some questions was raised from other platform. So this is for Linan. Linan, after completing the trust, do I need to follow up on it or maintain it?
Oh, there is no actually like maintenance per se each year, But like I said, you should like really do your funding really well. Of course, we will provide guidance along the way. And also if there are like major life events happening to you, like, if you have more kids, or if you get married, or if you're divorced, then of course you should re-examine the estate planning you already done. And also one more thing is that if there's major tax law changes, then you should review your trust again. And because there are some structure might need to be adjusted.
Okay, and then do living trusts affect estate taxes?
If it's structured well, it can delay paying estate tax. But the main purpose for living trust is not to avoid paying estate tax, and it cannot do that.
Okay, and do clients need to clearly list their assets to the lawyer?
Yeah, we prefer that you do that, because for two reasons. So there are some structure that can be decided by the total value of the assets each individual or the family owns, and it will be like different. And also, we need to provide the instructions for you as to how to fund your trust. So we need to know what types of properties you actually have.
Okay. After the house is put into the trust, will it affect the subsequent sales, refinance, and property tax calculations?
Well, almost no. So if you sell the properties, you are basically selling it directly from the trust. And if you acquire a new house, you should remember to tell the title company that you want to hold the properties in the trust name. But if you refinance, and I think that's the only time that might affect it a little bit, I think Richard will be answering the question better than I do.
Yeah, so maybe just take it out of trust for a day and then put it back.
Yeah, and I think the title company is going to do that.
If you're doing a refinance within trust, most lenders, it really depends on the lender. We rarely see a lender that's not allowing that you put it back to the trust. And usually that's done simultaneously. So you really don't need to delay like a day or two. It will be done recording together and with the deed of trust.
Okay, great. And from Nima, I have a property with my sister, joint tenancy, 50% each. We're both single. Can you advise if my sister get married and if she dies as a married woman, what would happen to her interest, the 50% of property? Does her shares actually come to me automatically?
Coco, I actually is typing to answer the question, but too many questions I can't answer.
Yeah, you can go ahead and just tell us.
I just address that what I typed to Nima over there. I said, hi Nima, only if she put your name in her will. And you may have to go through the court probate. Most likely, if she is married, the court may consider her spouse's interest if she doesn't name you as a heir of this property. So it really depends what her name in her will,
So even if it's a joint tenancy, she doesn't get that automatically because she got married. Is that why?
They are not a married couple. They probably won't get it automatically. They still get through the program.
Okay.
Oh, I'm sorry. Joint tenancy, right?
Yes, so she and her sister are actually holding title joint tenancy when they both
married.
single. When they were both single.
Stop over here. I think I answered too much. Let's involve attorney. What?
Yeah, if joint tenants, then the sister is going to get the other half automatically.
Yes. Okay.
Even if the sister actually got married after the joint tenancy was established, right?
Yes, correct.
Because when they have the joint tenancies, the sister will be holding as a single person at that time. So after they get married, after she get married, does she need to change the title to be married but as separate for that 50% portion?
No, it didn't. If they're in California, then it's actually already her sister's separate property because it's acquired before the marriage. But I think this sway away a little bit from our topic today. It's more to the marriage regarding the marriage law.
Okay. So from Frank, if you own rental properties with your parents in joint tenancy and the parents dies, what are the property tax ramifications?
So it's a related tax. I also talked to Frank, says you will pay the same tax amount after tax until you sell the property, because the property will not sell, they will not get reassessed. And he probably gonna pay their parents' property tax if he choose to live there, you know, as a primary residence, you know.
But it's a rental property. If you own rental property with your parents, so it's not a primary home.
So it's, Frank says, the rental property with your parents in joint tenant. So according to what Lina just said, in the joint tenant, all the property will transfer to remaining
Surviving
owner.
parties.
Yeah, the surviving joint owner. So it's gonna belong to Frank. So
But what
Frank
about the property taxes?
the property tax still stay the same. He hasn't sell. You know.
Oh, only when you sell it. That's when you choose.
Well,
Okay,
either
that's when the
sell
property tax.
or transfer. You know, this actually is not a transfer on the market. It's only transfer through the document. You know,
Okay.
inheritance. You know.
So when you inherit, and then that will
You
actually.
basically pay parents' rate. You know.
Okay, got it. So from Jeremiah, do you recommend establishing a trust for a married couple with no kids and assets set as joint owned? So cars, homes, etc. So no plans for children. Do you recommend a trust?
Well, yeah, but I think that also depends on the value of the assets. But since you own cars or houses, is probably already over the limit for a small estate. So you should still think about after both of the couple. After the couple both pass away, then who's going to get the properties? And whoever that is, you probably don't want them to go through the whole probate process, right? So it will be helpful that you set up a living trust and specify, who's going to get what from your estate.
Okay. And from WW says, non-resident from Hong Kong bought house in the US but doesn't live in the US. Are there any gift tax or other taxes if gifting the home to a relative in the US during his lifetime? If already bought the house under his name, what can it be done now to pay less capital gain taxes and other taxes?
Well, let me answer this. To pay less capital gain tax, well, anybody, no matter their immigration status, they still gonna pay the same, okay? The only way you pay less capital gain is if you in that year you have a capital loss deduction. So if you have any stock, if he invested in his name hasn't sold, maybe he can sell to against the capital gain. It's one way to do this. The other way is some other deduction like business deduction. So you have to think about the other way, not only in the house. If that house they make, no matter how much money, the U.S. citizen, how much we gonna pay, and the immigration guy gonna pay. Okay, so he has another question asked: what's the gift tax? If the foreigner, the relative, they only can give 60K for the property situated in the United States. So if he give the property to the United States relative, he probably gonna facing the gift tax at the 35%. So the best way I recommend it is to sell to the relative, to sell somebody else, transfer the money out and transfer money back as a foreign gift. Forget about it to give the house over here. You're gonna pay gift tax plus if somebody sell, you're still gonna pay the capital gain tax over there.
Okay, so from there's a question from YouTube live stream. What is the step up in basis that Biden wants to eliminate?
Well, Biden just gonna say when people dies, all the capital gain they enjoyed to the end of the day, government still gonna tax you. You're still gonna pay. Right
Okay.
now, you can use a step base to use your state tax about 11 million to offset all the step base. Biden just gonna take out the 11 million deduction there.
Okay. From Rose, actually, I want to save this question. Rose said, please comment on how Prop 19 will affect living trust. We'll save this question to the end. Not only that, but also I want to let everybody know December 8th is our special session for our CPA Zhai to do our tax planning for the year. And then December 15th is my session 3 for the Think and Stay Rich series. And that's a session specifically and entirely just on Proposition 19. So if you can join us on December 15th just for Proposition 19, that'd be great. So I'm going to save it for now, and then we can come back to this one. From Rupa, if both parents die and kids inherit the property, what are the tax implications for the kids?
There's no tax implication. They just skip all the step up, right?
The kids inherit all the properties.
Yeah, and if the kids sell on the second day, zero tax as long as the gain is not over 11 million.
Oh, that's cool.
That,
And then speaking of the
that's
11
a
million.
tax at the benefit, step base.
Okay. And then speaking of the 11 million, there's another question.
Okay.
I heard this 11 million lifetime gift tax exemption could be reduced to as low as 3.5 million.
Right. It's possible to the pre-Obama time, Yes, we don't know, a lot of things we don't know right now. We don't even know if it will get a smooth transition, but just be prepared, it could be lower or as low as a 3.5 million. A lot of people think, so government can tax more people at the death,
Okay. From WW, are tax rates the same for non-resident and U.S. residents when they sell houses in the U.S.? What are the federal and California tax rates when sell houses by a non-resident?
So let's assume all the house was a holding period over 12 months. So it will consider as a long-term capital gain. And long-term capital gain has a 3 tax rate. If your income is less than certain, let's first state the rate. His first question is non-resident and the resident, are the rate are the same? Yes, they are pretty much the same, okay? Just the U.S. Resident also have a W-2 in their income to pay. So the capital gain is set on the top of their W-2. So their tax rate could be higher than the non-resident. They don't have W-2, they only have a capital gain. So normally, if your income is under, let's say 50K for individual and 80K for the couple, the capital gain are 0. When from the 80K to a single 40K married couple about 60K, the capital gain are 15%. When the single over 40K married couple 60K, and your capital gain gonna be 20%. That's only for the federal. The California tax about over 90K is at 9.3, then $500,000 is at 10.3, somewhere it has 11.3. California can all the way go to, if over $1 million, a lot of house can sell over capital gain over $1 million in California now. You're looking at the California can be paid as of 13.3. And also, there's another tax, it's Obama tax after 2013. If your capital gain over 200K and marry over 250K, you're looking at the 3.8. So let's count how much total tax. If you sell over $1 million, no matter you're a foreigner or US citizen over here, you're looking at the pay federal 23.8, California 13.3. So the two add up is about 35.1,
I hope you're making good notes for all the percentages.
That's about 35% on the gain, as the
Okay.
highest rate.
From John, in light of passage of Proposition 19, so another Proposition 19 question, what impact does it have on the strategies presented here? Also, is there any thoughts about how to maximize on the benefits of this new law? So I again want to save this for December 15th. That's our special session just for Proposition 19. Then from Wendy, if no minor children can, and only adult children for living trust, do we still need a third person as something, forgot the title.
Successor trustee, yeah.
Trustee,
So
between the grantor and the beneficiary.
yeah, so there's no need. So if your children is responsible adults and they are your beneficiaries anyways, you can certainly designate them as your successor trustee. So basically what they are doing is after the parents die, they just transfer everything into their own name, and that's it.
Okay. From Rupa, can we add kids as joint tenants anytime to primary residence? Is that a good idea? I think we actually mentioned about co-owning with children, right?
Right, that's not recommended.
Not a good idea to co-own. Yeah. Okay. And then from Eileen, is in joint tenancy holding method, if one owner dies, should the other owner go to title company to change the holding method? Maybe that's Richard.
It's really I can't really tell you yes or no, but what I can tell you is in our actual practice, if we see, let's say, a joint tenancy, right, and we know that somebody, one of the owner died, what we're going to require is to ask the surviving person who are selling the property to get a death certificate, right, and then we're going to sign a couple more documents, and then you can just sell the property that way. Okay. So if you feel that you need to do that, certainly, but I can tell you that as long as there's a sufficient document, we'll let the property go. But I don't know if by not doing that, is there going to be any legal consequences or any? I don't know. But
Linan actually have some answers for this, right?
Yeah. I just answered that. Any attorney can actually take out the name, and they will need the original death certificate.
So there will be a step required, basically, or
yes.
Richard, you thought maybe they can just sell it just with the death certificate without the actual.
Yeah. That's not a master step. But if they want to show that the house is currently owned by only one person, then they should do that. They should remove the decedent, but it's not required.
They should always talk to attorney or CPA, because for us, we're just doing the transaction. We're not talking about, for us, title company, we're not talking about the purpose of doing so or the tax consequences by not or by doing so.
Okay. From Raw, if husband passed away, can property title change to wife owning if the original title is joint community property? I think it's community property survivorship. Will it go to probate? So I think the answer is you will automatically go to the wife.
Right, yeah.
Will not require probate.
Mm-hmm. Yeah.
From DYZ, to prevent inheritance limit to 3.5 million, is it a good idea to give the real estate to adult children now, since it's 11 million now? Bing?
Yes, you could do that. A lot of rich people, maybe super rich people, is taking advantage of 11 million now. And we think even the limit go down to 3.5, the Congress will not come back to ask the money back, says you cannot give 11 million. So a lot of people, we even suggest for the people who gonna touch more than 11 million to give up to somewhere up to 11 million, they can give away now, to take advantage of 11 million,
as long as they don't take it back.
As long, yes, what you say?
As long as they don't take it back, right?
they cannot take it back. If you take it back, the kid's gonna count another gift. You're gonna have a double gift limit being wasted on the same property there. So you have to think about it very good, think through, and you have no more than one month to do that now,
Got it. Only 1 month to give away all your assets to your
all
adult
your
children.
fortune, if you think you're not gonna spend that 11 million to the day you croak, you probably should do it now,
Okay. From WW, what's the best way to hold title of a house for non-residents living out of country to avoid taxes? For example, LLC or corporation, etc. If already bought the house under individual's name, what can be done now so we can pay less taxes?
I do have a lot of suggestions, but Lina, do you have any?
You have a lot of suggestions, or you do not have a lot of suggestions?
I have a suggestion. It really depends on what they want to do. Are they gonna take money out of U.S. or not? In my real case, I suggest people to use LLC and or use some corporation. But for a lot of my client, if they have a special needs or they want to have the money, they don't want the money go back to China. I don't know why, but they always tell me if I got the money out, I never think about it to put them back because it's really hard to get the money out, in the current situation. So if they want the evergreen to leave the money in the United States, we probably suggest them to use a irrevocable trust,
Okay.
because as a irrevocable trust, you still pay the tax, but you can transfer, then you don't need to pay the estate tax, because for the foreigner, their estate tax exemption only 60K,
Okay.
Yeah.
So there's a question for Linan. Can overseas property be loaded?
What does be loaded in, what does it mean? To load to where?
In your trust, overseas property.
Oh, okay. So yeah, so estate planning is very like country specific. So if you own properties outside of the United States, you should really have estate planning in that country to cover the properties in this area. So basically, if you do estate planning in the US, it only covers properties that are situated in the US.
Okay. Does the living trust need to apply for a separate tax number?
No. So living trust, if there's any possibilities that they ask for the tax ID for the living trust, they will use the social security number for the grantor or the the initial trustee. It does not need to apply for a tax ID individually.
Okay. And you mentioned the pour over will clause. So if I owe a lot of money before I die and I forgot to transfer everything to my living trust, even if I have a pour over will clause, can the creditor still go after my assets that are under my individual name?
The creditors will be treated as these properties are already in living trust.
So they can?
So no, they can't.
They can't. Okay.
Yeah.
Will the pullover clause help you avoid probate?
Yeah. Yes.
Okay. And then from Nima, can title company change the title from tenancy in common to joint tenants? If yes, how much it would cost?
If you're talking about just changing that without the transaction, no, we don't. Most title companies do not do that anymore. In my career, I went to 4 different title companies, about 15 years. The reason behind that is there's a lot of tax consequences involved. For example, parents give it to children, seemingly an easy process, but that, if the parents happen to be a foreign person, just like being said earlier, you could trigger tax and stuff, and we don't want to be liable, so we don't do that. If you want to save money number one, you can find a paralegal do that easily. They probably charge you a couple $100, and they probably also include recording. But if you want to do that through a transaction, you can do that within a refinance. If you want to do within a refinance, as long as the lender is okay with it, title company can do that and during closing.
It's actually quite easy when you do through a refinance, because they just do a grand deed at closing. So
as long as the lender is okay with it.
Most lenders should be okay as long as the names on the title does not change. So it should be really easy. Yeah, thank you. From WW, will non-residents pay less taxes living out of US, when sell the house if holding title under a LLC or corporation?
I think my recommendation is they pay the same tax. If LLC is just a pass-through entity. LLC that does not pay any tax. All the gain pass through the individual still paying. And I don't know if you want to consider use a corporation to hold the real estate. Sometimes make sense. Very few, a lot of time they don't make sense, and you're gonna pay the tax double time because the corporation pay the corporation tax when you distribute it as a dividend. Maybe you pay another dividend tax. So really think about if you want to use a corporation to avoid in tax. My straight answer is you probably won't be able to avoid the tax over there, and the corporation probably gonna pay more, you know.
And I have an idea. We're going to hold a seminar about different ways of the corporations LLC, what the purpose they are for, and whether you can save taxes or you just for protections, legal protections. That'll be our next coming up seminars. Yeah.
It turns a lot for the people who doing business, you know. In the business person, you really need to understand how to different the corporation for what purpose. You know?
Exactly.
Otherwise,
yeah,
you're gonna pay a lot of tax in the end, you know.
Double taxing, yeah. So there's a question from Shirley, but I think Linan already answered. That's regarding the insurance, right? So the benefits. So thank you very much for sharing with us today, Linan, Bean, and Richard. And thank you to all the viewers for joining us and also participating. We sure learned a lot about titles, probate, estate planning, and living trust. So I hope your questions have all been answered. I understand I have 2 questions saved on Proposition 19. I really hope you can join us on December 15th, just a special session for Proposition 19. We will also welcome everyone to participate us for the next lecture from our CPA on December 8th. That's strictly just for our year-end tax planning. So we will now stop the recording, but please feel free to stay around to chat or network. If you have any real estate related questions, we'll also be available as well. Happy Thanksgiving, everyone, and good night, everyone. I'll stay around.
Thank you very much, Coco.
Thank you so much. Yeah, thank you. I'm going to stay around. So Bing and Nina.